Hi, Vanessa. Thanks for joining me today.
Thank you so much for having me, Jack.
I've got Vanessa here from HR Maximised, and I'm just wanting to chat to her a little bit about changes in the fair work space with the current climate and what's been going on with COVID. So, what do employers need to look out for in this space, Vanessa?
Thanks, Jack. Look, the first 6 months of 2020 have been huge in the employment space. And even pre-COVID, we had quite a number of changes happen in the fair work space. And that has continued to grow with COVID. So there's a lot going on at the moment. So I'll briefly touch on them. But what I want to say at the outset for employers is, one, don't panic. But two, be aware of what your obligations are. And if you're in doubt, then please seek help or assistance with this, because your obligations don't just, for unfair dismissal, those obligations still apply, but also too for any under or over, certainly any underpayments, that obligation is there for 6 years. So you want to minimize and mitigate your risk as much as possible. So don't panic by any of these things that I say now, but by all means, make informed decisions and start to seek out some help and advice if you need to. So one of, obviously, the big one that we have is JobKeeper. And JobKeeper, was there to design to keep employees and employers engaged and connected together, and also to help employers during this time and subsidise their wages. So outside of that legislation for the subsidy of the wages, we also had a change to our Fair Work Act in what is called JobKeeper enabling directions. So there's quite a number of these directions. It's all about trying to keep employees engaged, but also from an employer's perspective, they gave the employer more power in being able to direct some more favourable aspects for the employer than employees. So some of these things were about stand down and changes to hours and work and changes to duties, which may have been protected under their awards previously. So this gave employers more rights or powers in those respects. But I want to caution employers on this one. Just because you are under JobKeeper doesn't mean that you can just enact one of these enabling directions. There's quite a number of processes and procedures to do before doing that, and the fines are quite big, Jack. It's about $160,000 per employer for an individual employer. So you don't want to get it wrong.
That can add up.
Yeah, you do have rights, but just make sure that you're doing it in the correct process.
Yep.
And that's the key thing, Jack, is that all the processes and procedures still apply. Unfair dismissal claims have skyrocketed during this period. And that doesn't mean that the employers acted wrongly. What it means is that it costs $73 for an employee to lodge an application. And in this really tight job market, they are scared. And so they think, well, why not? I'll give it a go. I've got nothing to lose. For $73, I might. So you want to make sure that any action that you're taking during this time is really considered and you're following the correct policies and procedures, because you just don't want to end up in unfair dismissal. It's a lot of stress, it's a lot of extra resources, and it's money that you may not already have in your business. We've also seen in the last week a lot of changes happen to the casual employment sphere. There was a high court ruling just in the last week or two around casuals, and that decision is going to have massive impacts for employers with casual employees. So I'm recommending that any employer that has a casual that has worked with them for greater than 6 months, you really need to review your employment relationship with them, because if they are working anywhere close to regular and systematic hours, then the court case that came out in the last couple of weeks means that that employee was paid their annual leave, they were eligible for annual leave, personal leave, compassionate leave, public holidays, and it all had to be paid out at that higher rate of the casual loading. And they weren't able to offset that loading against those entitlements. So really key at the moment that if you have casual workforce, that you are reviewing that obligation and make sure that you are know what your obligations are, and just be aware of it. Don't act right now, but be aware so you can make informed decisions going forward. So Jack, it changes really quickly in employment law at the moment. There's a lot going on. So, find a reliable source of information. You can follow HR Maximised either on Facebook or LinkedIn. We post regular stuff, but whoever you choose, just make sure that you're keeping up to date and informed and just making considered decisions with your employees.
Wow, such a minefield of things to get through that people really do need to just take advice and make sure they're up to date on what's on the current situation. So
yeah, and those obligations to the underpayments, Jack, too, that lasts for 6 years. So even if you terminate an employee, that doesn't mean that that obligation has gone. So you want to make sure that you're mitigating that risk as much as possible.
Right, absolutely, some really good advice there. So thanks so much, Vanessa. Much appreciate your time this morning.
Thanks, Jack. Really appreciate it.
Bye-bye.
Bye.